Welcome to the Tenant Law Podcast, where we talk about new, interesting, and/or important legal cases affecting New York City tenants. This weekly pod will be about 10 minutes long. First, we give you some background so you have the context to understand the case we're discussing. Then we talk about the case itself. And finally, we explain why the case is important and give you our tenant takeaway. I am Michelle Itkowitz, and today's case is Ahmed versus Reed, a fairly recent New York City civil court decision. So let's jump right in with our context. So, in most instances, when a landlord wants to sue a tenant to get rent or to get an apartment back, the proper way for the landlord to do that is a special type of lawsuit that is known as a summary proceeding for the recovery of real property, which is brought in the New York City Civil Court. So that's a big mouthful. So we have a simpler way of referring to these cases. We call them housing court cases. So instead of saying summary proceeding for the recovery of real property in New York City Civil Court, we say housing court. And the irony is there is no housing court. There really technically is no housing court in New York City, but we all call it housing court. There are two types of housing court cases for landlords to bring. One is called a non-payment, and that's when the landlord is suing for the rent. And the other is called a holdover, and that's when the landlord is suing to get possession of the apartment back, either because the lease has expired and the tenant is not rent stabilized, or there is no lease, or the tenant did something really bad and the lease ended early. So that's a holdover. And today's case that we're talking about is a holdover. So now you have your context. Okay, in today's case, the landlord rented to tenant an apartment called the first floor apartment. The landlord called it the first floor apartment. The tenant called it the first floor apartment. It's unclear from the case if there was a lease that referred to it as the first floor apartment, but nobody's arguing. Everybody involved was calling this apartment the first floor apartment. So when it came time for the landlord to do a lawsuit against the tenant, it described the apartment that it was seeking to get possession back of as the first floor apartment. The problem is the tenant came into court and said, hey, wait a minute. I don't live in the first floor apartment. I live in the second floor apartment. It was one of these situations where the physical first floor of the building was described as the ground floor, and the physical second floor of the building was described as the first floor. So this was the situation. And the court said, you know what? I'm going to dismiss this case because this is what could happen. If the landlord goes forward in the case and wins the case and gets a judgment of possession, and then the clerk turns that into a warrant of eviction and gives it to a New York City marshal who's going to go out and evict. When the marshal gets there, they could make a mistake. They could be going to evict someone from the first floor apartment when really they're supposed to be looking for someone on the second floor apartment. So this isn't just a typo, it's an important problem in this case, and the case was dismissed. Now that brings up a very interesting tenant takeaway. First, housekeeping. This is not legal advice, and I am not your lawyer, but because I am a lawyer, this might be considered legal advertising. If it's legal advertising, it's horrible because I'm asking you not to contact me. This pod is not a commercial for me or for my law firm. This is simply the podcast that I always wanted to make. Email us with your questions. I might be answering listener questions on the pod, but not announcing your name. I'd just love to say what New York City neighborhood you're from. If you like our work here, please buy us a coffee on Buy Me a Coffee. The link is in the show notes, and please give us mountains of stars. It is time for the tenant takeaway. Tenant takeaway time. Some people would describe this case as the tenant won on a technicality, as if maybe the tenant shouldn't have won, like it was a loophole or something. Oh, tenant won on a technicality. But that's just not accurate. For sure, this was not a decision on the substance. The court never got to the end of the case and said, okay, this holdover wins because the tenant isn't supposed to be there anymore for whatever reason. The court never got that far because there was something wrong with the legal papers. They were describing the wrong apartment. So the point is, winning on a procedural issue, however, is just as valid as winning on a substantive issue because that procedure is there to protect everybody. Do any of us want New York City marshals running around evicting the wrong people? I mean, that doesn't help anybody. So, takeaway number one is that procedure is as important as substance, but that's maybe more of a comment than a takeaway. But it sets the stage for our real takeaway here. Tenant won a battle, but we don't know if the tenant's going to win the war. We don't know anything about the case. So, what was really the value of this dismissal? This landlord's just going to go back to its office and start another case that afternoon. So, what was really achieved here? Well, sometimes buying time is in and of itself very valuable. More time to move, more time to get money, to pay the rent, more time to make a decision. Sometimes time is valuable. But other times, time isn't that valuable. I do a lot of cases where I'm trying to fight for rent stabilized apartments for tenants. And in those cases, I don't really want to win on a procedural ground. I want to sort of be a diversion. I want to get to the end and hopefully get a tenant their forever home if we prevail. So time doesn't always have value just because it's more time. What I'm suggesting here is anytime a case gets dismissed on a procedural ground, tenant has gained something beyond time. And that's very simply leverage. You've created some leverage because from the landlord's point of view, they've come all this way. And now it's like, do not pass go, do not collect $200, move your piece all the way back. So that is a downside for landlords. So that creates some leverage. So rather than waiting for landlord to start another case, it gives the tenant an opportunity to say, hey, landlord, look, I'm sorry you lost the case. It was nothing personal, but rather than starting again, can we just make a deal here? I need fill in the blank for whatever the tenant needs. So leverage, because a win is only a win if you can do something positive with it that moves you towards your goals. And there you have it. Remember, New York City, the law belongs to you, but your ownership of the law is only as great as your understanding of the law. So let's learn to live better. I am Michelle Itkowitz, and this is the Tenant Law Podcast.